So let me welcome you on behalf of the North San Diego County Realtors, your best association in San Diego County. My name is Fred Pfister. I am the general counsel for the North San Diego County Realtors, and I'll be doing a presentation today on some forms that are in addition to the RPA, but we'll be going a little bit back and forth. I do a number of presentations. Some of you may have seen me before, but I'll put up my shameless bio in just a second here. And while I do that, let me put this forward here. Okay, so there, I think you can see, here is the title of today's topic. I hope everyone can see this. It's ancillary forms to the purchase agreement. And so what we're going to be talking about is what I think are some of the key forms that you take a look at when you're doing a transaction. This course may be a little basic for some people. For other people, it may be, some eye-opening issues. The way I do my presentations is I really like to focus on what I see are disputes. Here's my shameless bio as to who I am and what my firm is. I hope a lot of you have heard of White and Bright. We've been around. This is our 41st year, which is very exciting. I do litigation and transactional work, so that you know my background, and I particularly focus on the defense of realtors in actions where they're either being sued by buyers and sellers, or they're being, or their claims are being made, and that's often, that's what I would call pre-litigation. But that's the type of thing that obviously comes a lot more than litigation, right? You get claims against you often in these transactions, and then sometimes they end up in litigation, sometimes they don't. So the way I like to approach these presentations is giving you the insight into what I see going on. Particularly, the current day. I mean, I have calls like this, before and after these presentations on these very issues. So I like to highlight things, and then I like to highlight areas where I see people tripping up, particularly when I'm talking about forms. But I do teach a number of other classes, particularly a red flags course is what I call it, which is all the disputes that you often see, the non-disclosure of material facts. I teach an financial elder presentation, and several others. And some of you may have caught my 3-part RPA training that happened in December and January of this year. So there's my shameless background. Like I said, this is what we're going to talk about here today, though. What we're going to talk about is forms. If any of you have been paying attention, you know that the RPA was radically changed, hence the 3-part series on that. But you may not know that a lot of other forms were changed at the most recent cutoff in December. And in fact, in the past 2 years, I think there's been more changes than ever in terms of the forms. I think it was something like 70 forms in December were either altered, or there were new ones, or replaced. I mean, that's just a staggering amount to be able to remember. And so I think it's sometimes helpful, even if you know these forms pretty well, it's sometimes helpful to walk through them to get a refresher on the information. So what are we going to talk about today? We're going to talk about these are essentially selected forms, and forms that I see disputes on. So certainly the seller counteroffer, I want to highlight a couple things there. The seller property questionnaire, the SPQ that we all know and love. There's some changes there that may be subtle, but they're trip ups for you. And so, and they're in response to litigation and to a lot of claims that we actually see. So I want to highlight that. Then we're going to look at the request for repair, and my favorite form, the RRRR form, which is that the response. I love that acronym. And we'll talk about contingency removal, because that has changed, and I think it's become a very important form It was always an important form, but I think it's become particularly important, at least I've seen in the transaction, and it has a lot of disputes over it. And then last, we're going to talk about the notice to buyer to perform and the notice to seller to perform, because those forms essentially go together, but we're getting a lot of disputes on that with a lot of transactions that, at least in the last year and a half, that have not closed for whatever reason. And so we'll talk about how to deal with those forms. Okay. So another administrative item before we get going. I know that there is a chat function on this, and I know that there are questions. What I'd ask is if you put a question in there, I'll try to mostly get to it at the end. It's somewhat difficult to navigate the forms, because we're actually going to look at the forms, navigate the slideshow, and then also answer questions. But it's not that I don't want questions. I certainly do. And I will give you my email and my phone number at the end, so that you can certainly follow up with me if you have specifics. I don't pretend to know everything about every single form or every different scenario. There's a lot of nuance that goes into some of these scenarios, but I'm happy to answer questions, particularly at the end of this presentation. I know it's slated for an hour and a half. I don't think we will take all that time, but let's get going. So the first form we're going to look at is the seller counteroffer. And what I'm going to do, and this is I'm going to go through each one of the forms. I'm going to pull up the form. So I'm going to get off this slideshow, pull up the form, and take a look at it in some detail, so that. But here's the what we're going to look at. How does this form work? What are the other terms, and what are some highlights there? The use of the attached documents, and then obviously we're going to look at what's changed. So let me pull this off here, and I'm going to pull up the actual form itself so that you can see what we're talking about. Okay. Hopefully everyone can see this form. This is the seller counteroffer 1. Now obviously that there is a buyer counteroffer form, but they're substantially similar. So I only wanted to focus on this one because this is the one that's often used. You get an offer in, and then you have a seller counteroffer. Is most of the time the way these things go. Most of the transactions I'm seeing have a counteroffer element. People, it's a seller's market, as we know, and it's been that way for some time. It may reverse here with interest rates going up, but until I really see it happen, it's still a seller's market. And so what I'm seeing is sellers are countering quite aggressively on offers. Even really clean offers, they're countering pretty aggressively, not only on price, but on terms. So, what are we looking at here? And the way this generally works is by default, it's a counter, and I hope you can see my cursor. It's a counter to the purchase agreement. Or you can select whether it's a counter to, a buyer counteroffer, a buyer counteroffer, and specify the number, because there could be, you could have multiples that go back and forth. What that does is, by doing that, it incorporates those documents into this document. So it's incorporating the other terms of the purchase agreement into this, or a particular buyer counteroffer if you're countering to that offer. So if you're wanting to alter the terms, you're going to have to do that here. Otherwise, those terms are going to continue on. The one thing that I wanted to highlight here is what's in the what's new section is this sentence here about liquidated damages and arbitration of disputes. Now, why is that important? Well, that's important because a lot of people forget to check that. And what they're reminding people is that if you don't have both parties' initials on those items, then that is not an agreement on that particular item, but it still can be an agreement on the contract. So let me unbox that. If one side checks the arbitration and the other side doesn't, you still have an agreement on the other terms. You just don't have an agreement on arbitration. Now, most people by default, I mean, when I talk to actual, people who enter into these contracts, they don't know half the time whether, I mean, I count on one hand the times I ask, did you check the arbitration box? They have no idea what I'm talking about. They just see a DocuSign and they click the DocuSign. What that tells me is that the agents aren't necessarily walking them through what arbitration is, or even giving them sometimes the option of doing that, which I think can be somewhat, I wouldn't call it dangerous, but it certainly is something I would want to talk to my client about before they just initialed something like that. But what this is it's a reminder to the parties to initial that if they didn't already, because CAR really wants people to use the liquidated damages, and they want to use the arbitration of disputes. Now, just to let you know that that's on one page of the RPA. If you're using the new RPA, it's on page 14, and I'll pull that up for you so you can see. And we're going to toggle back and forth between the RPA today, because sorry, let me make sure I have the right page here, page 14, and I will show it to you. And here's what I was talking about when I said the initials. So this is where the seller's initials, buyer, seller initials on arbitration and liquidated damages. CAR certainly wants those to be used, and this is where you would specify. For those of you who missed the RPA class, you'll notice that there is a new section here in the arbitration disputes where you can specify who you want to be your arbitrator. I have yet to see someone initial that in the last 3 months, or someone include who they want the arbitration to be, but it's out there. But that's this is that new page that is in the RPA. So let's go back to our other document here. So we're back to the seller counter offer. And what else? What do we have? What are other terms? So the other terms section is, where you can specify what terms that you want, to be included as kind of a catch-all. And I would be very hesitant, and I just want to make a mention here of this, that to use caution when you're doing this. And this is a good example of an area where you likely want to run this by your broker, or if you are a broker, put a practice and procedure where people put in, where agents run these items by the broker prior to sending this over, because I've seen a number of disputes in here, and it's based upon being what I would call vague language. Is they put it, they try to make, they go under the maxim of simpler is better, which often is the case, but there's a reason why the RPA is now, 16 pages? It's because it's detail oriented. And when you have a document like that, and then you insert something that is somewhat of a vague term, or, my classic is, buyer and seller to agree on X in the future, on use of property after close, or something like that. Because the buyer, because the seller wants to do something on the property. Well, what if they don't agree, right? I always hate agreements to agree, right? Yeah, we're gonna work on this later on, or the classic is, there's a section here to rent back the property, but I've seen situations where instead of, clicking that section, the RLAS, they say that the parties will agree during escrow on a sufficient rent back. What if they don't? What if they don't? Who's in breach? Now you had this vague clause that was in the counteroffer that your guys are going to agree. Are you really going to agree? And guess who they're going to look at and say, why didn't you tell me it'd be really difficult to negotiate a lease back? They want 6 months. I thought they wanted a month, or they wanted 2 months. Now you're telling me 6. I can't get my kids into school. I can't do this. I can't do that. So before you would start inserting other terms, I would say it's, talk to your broker. This is something that sometimes simpler is not better. And the big caveat here is it depends, right? It really depends on the facts and situations of that particular case. And I'm happy to answer questions on that when you have them. And I answer questions like this all the time for realtors, because that is a point of contention. So I just wanted to mention that. What I was referencing here is this section, which is all these documents. This is section 1D, where you can incorporate these documents into the counter offer. These are all the forms that we all love to hate. I can't tell you how many disputes there were over these in the last 2 years, particularly. I think it was a function of coronavirus and the hot market, but we had a lot of tenants or sellers who actually didn't want to move, even though they were selling, or they wanted to somehow, kill the transaction. Very unusual, but these are the documents. These documents have been cleaned up over the last year. A lot of them are new, or not new, but they are heavily revised. And so I would encourage you, if you're making offers, to study those forms. They're not part of today, but certainly study those forms, because they are becoming extremely important in your practice. And I see a lot of agents don't necessarily understand them. They kind of like push them off, unfortunately, to the buyer, and then the buyer doesn't know, or the seller, as the case may be. One last thing I want to highlight on this document, and this is this new section here regarding the terms and conditions of those documents are incorporated into the seller counter offer unless otherwise agreed. Now, I don't like this sentence, because those documents, it sounds kind of vague as to what we're talking about. But my interpretation of that is we're talking about these other documents up here. But this term "otherwise agreed," I don't know if you picked up on that. It's a capitalized term, and what that is if you look at the RPA, the RPA has a lot of the new RPA has a lot of new definitions, and this one is 25O. Paragraph 25O, and what it essentially means, unless there's another agreement in writing. So there's like kind of this catch-all now in the RPA, where it says, where they recognize that a lot of people they make kind of side agreements. I don't always advise that, but they make some kind of a side agreement, and this references that. So that "otherwise agreed," make sure this is a reminder to look through the RPA if you haven't already, and reread the definition section, because a lot of them have changed, and there's a lot of new definitions, including something like "otherwise agreed." Okay, so I'm going to go back to our PowerPoint because we have our next form. Which is the one that everyone loves to hate, the seller property questionnaire. So the SPQ. Now, we get lots of disputes over this form, but when I start with this, before I go into the actual form, I just want, because this is what we're going to talk about. I'm going to talk about how this works. It's certainly that first section of the SPQ. I'm going to talk about how do not fill this out for the seller. This is a seller property questionnaire, not an agent property questionnaire. But that doesn't mean that you can't go over this with your client. We're going to talk about what's changed, because they seem like they're subtle changes, but I think they're extremely important, because it's a trend in the law and a trend in disputes that they're trying to fix. So they're seeing, I think, lots of disputes over this certain thing. And they've changed it to try to address that. And then I'm going to talk about a common disclosure scenario that comes up a lot, and it's really, I think, being addressed by the new seller property questionnaire. So I know everyone's has some anticipation there. And so let me share the SPQ for you. Okay. I apologize, I'm going back and forth on these forms a bit, but I know that it's helpful to get these forms in front of you so you can see the actual form itself. So here's a seller property questionnaire, and you can see it was just recently revised. And again, I can't emphasize this enough that the seller fills this form out. But one of the biggest complaints that I get on the buy agent, so not the sell agent, but on the buy agent, is that the buy agent did not go over this with them once they received it. So once you received this from the seller, they didn't go over this with them. They just kind of handed it to them and said, sign this. And they didn't walk them through, okay, what does this mean? What's the purpose of this form? What am I looking at? I often see that as they say, well, you breached your fiduciary duty because you said everything was fine. You said you reviewed the seller property questionnaire and everything was fine. Just sign it, buyer. And that is, I don't think that's the case every time. But I think it's important to have that meeting, to have, if it's over the phone or if it's in person, to kind of walk them through, highlight the items, and then follow up on the items that are of concern or maybe have questions. Normally, it's not necessarily you have concerns, you just have questions, because sometimes the answers are quite vague. And my pet peeve on this form is that the explanation section is so short. I mean, I'll show you an example. Your explanation is for all these issues. So you can have all these issues that, and then you have an explanation, and it's like 2 sentences, and it really encourages the seller to answer it very lightly. Now, if you're using some kind of software where this is filled in, if you're using, where you're not handwriting this, but you're actually filling it in, there is, room for more explanation. But the way this is structured, I think it kind of encourages people to write very, very, very basic information, and that has a tendency to under disclose, which it's rare. It's rare in my world where someone over discloses and they lose the sale. And when they over disclose, it's very unlikely they get sued. Where I come in is the under disclosing, is where I see a lot of cases. Almost all the claims are, it's a clean sheet, or it's like, fill, it says fill. It doesn't even say where the fill is. It just says fill, or it says, repair made. It's such basic information that you really don't have time, much less the enough information to really discover what's going on. But let me show you, because I said I would walk through how this works. So, I mean, number one is something I would emphasize with my client when they ask, can't you fill this out for me, or what's going on with this form? I mean, this sentence here, that these are representations by the seller and not the agent. It's not a warranty. This is kind of the protection language for the agent. But people just gloss over this, right? At least the sellers do. They don't necessarily read it. But this is the kind of thing I would walk them through. I'd say, you'd say, I'm the agent. I don't know all the things about your property. I just got here, right? I met with you at your property, and I took some pictures. I don't know the history of your plumbing issues, right? This is something you have to fill out. I cannot do it for you. And I would walk them through, additionally, this section, which is the purpose. What's the purpose of this form? It's really to answer, it's answer based upon their actual knowledge and recollection. And it's something that is material or significant, isn't necessarily material or significant to them, but it can be to someone else. So what this, I'm not going to hide the ball here. I mean, it's past issues that have been remedied too. So one of the things that this form now is trying to solve is, okay, you had a plumbing problem, you fixed it, give the information about the fix and about the problem. Don't say everything is fine, because what tends to happen in a number of these cases, and I've seen it time and time again, is, yeah, there was a plumbing problem. It was fixed. And they used an unlicensed contractor who didn't do it well. And 6 months after the buy, there's another plumbing problem. And when they go to investigate, the new plumber that they hired, the licensed plumber they hire, say this was done really bad. This looked like it was done, by a homeowner who didn't know what they were doing. And look, it caused all this damage and all this mold. And look, they covered it up. Because they'll say, look, they patched the wall and then painted over it. What does that look like to a plaintiff's attorney? That looks like a cover-up, right? That looks like you knew about the issue and you intentionally covered it up and painted over. And you're thinking, well, what does this have to do with me, right? I'm the agent. I didn't do that work. Well, what it has to do with you is that they might say something like that during during the listing. Oh yeah, we had plumbing problems. Yeah, we had, we just did a big repair to bathroom number 2. And then you as the agent, if you're representing the seller there and you don't advise them, hey, that's something we want to disclose here, then, could you be open for that seller coming back to you later and saying you breached your fiduciary duty, you didn't protect me? They'll certainly make the argument. I can't tell you whether you win or lose that case, but what I can tell you is that they might make the claim, particularly if it's a high dollar issue. So I want you to the gold standard would be to walk them through this and then memorialize the conversation. And what I mean by memorializing it, I mean follow-up emails, something in writing that says, yes, today we went through this form. You wanted me to do, I advise you to do this, this, and this, please do that before our next, as you fill this form out. Next issue here is, okay, so the buy side, people don't get out of this, right? So the buy side, here is the purpose. I'd like them to walk through this when they receive it. I mean, it's a note to a buyer, but there's no reason why the buy agent can't walk through this with the client and say, well, here's something, these are the significant items. This is the purpose of the document. It's important to you, put it in your questions, concerns. You can use the BMI form. So rare that someone uses that form, but it's out there. But I just walk them through this so that they know the purpose of this form and what they're getting into when they receive this form. But let's talk about what has changed here. And what really has changed is this no time limitation. So this, I'm highlighting this in section 4. I hope you can see that. But the real issue or the real change with this form is they're talking about it's not the current status of the property, it's what is historical. The trend now is to go to historical. And I'll give you this scenario. It's in my slides, but it's essentially it's happened so often with the flip house. And the scenario is essentially that you have a flip house, right? And I don't want to use that term negatively, but you have a flipper who comes in, buys a house, does an extensive remodel. 6 months later, they resell it. And when they fill out that seller property questionnaire or the TDS, what happens? It's blank, or it says something like extensive remodel. And they don't voluntarily provide the extent of what they did, or, which is what this is trying to solve for, those historical documents. So if I'm the buy agent and I'm buying on a property that I know is a flip, I want the original TDS. I want the SPQ from 6 months ago, because that might show me 15 problems and then I can kind of match that up with the current SPQ, and I could see, and I could say, well, wait, they said there was a huge problem with the plumbing. And I'll use plumbing again. They said there was a huge problem with plumbing. Bathroom 2 didn't work. or the shower was leaky, there was tile missing. I can see now that I'm in the property right now. I can see that looks like they repaired it. But gosh, wouldn't it be nice to have the invoices? Wouldn't it be nice to know who the contractor was who did it? Wouldn't it be nice to have that information so I as the buyer, I can give the option of verifying whether that was done correctly? I mean, so as the buy agent, I'm not saying verify that it was done correctly. That's beyond the scope. But what I'm saying is that's the type of conversation, the option you can give your client and say, hey, why don't we get those documents? Why don't we ask for those documents? They didn't provide them on the first go. And the client may say, I don't care about that. Everything looks great. Well, how do that's fine. That's their option, right? But they might say, yeah, that's a great idea. Ask for those, right? And so that's really what this is trying to solve for. So that's why you see it says no time limitation, because what they're talking about is historical documents, things that may have been fixed even. And so let me walk you through that here. If you look at section 10, what's new? Water intrusion, whether past or present. So if you fix something from 2 years ago, is that fair game to put in here? Of course. That's something you want to know, right? You want to know if they fixed it. Here's another one: past or present pets, past or present, livestock. Not a ton of livestock on properties, but there are some, certainly in North County as well. Is that an issue? Did the last owner before you perhaps have, a number of pets on the property? That's something that they want to know if the buyer knows it. Or, I'm sorry, if the seller knows it. And let me show you another one here that I see a lot of, or at least I've seen a number of recent disputes about, and they separated it out because I thought this was kind of a catch-all. So this is the A is kind of the old catch-all. Oh, is there a neighborhood issue? But look what they put in now. This B, any past or present disputes or issues with a neighbor that can impact the use and enjoyment of the property. And they want them to click yes or no. And this is the big one because, oftentimes people move because they have a problem neighbor. That's actually a common reason. And they often do not want to disclose that because they're deathly afraid that someone won't want to live next to the crazy person that's next to them. And that's a real problem. But if you're on the buy side, don't you want to know that? And so I think because, and this is just my thought, was that because this section 16A was so generic, it wasn't, even though it really, a neighborhood nuisance really is a dispute with a neighbor, people weren't interpreting it that way. And so they separated this out to highlight it and to get people to disclose this issue. So it is something that needs to be disclosed if there is a past or present dispute with a neighbor. A couple of other changes here. 17J, this is a highlight. This was also on the RPA, if you recall. It is the address or the mailing address particularly, is it different from the city or what has jurisdiction? There's been several disputes where people say, hey, I thought I was, my address says I'm in Escondido, but I'm really in the county, or something similar to that, where it says my address says Vista, but I'm, but I didn't know I was in the Bonsall School District or something like that. And so that's a section here where someone can disclose that issue, and it's also on the RPA. There's another section. Last one as a new item here is this is how you know we're in 2022. There's a cannabis question on here now about any alterations to the use of the property due to cannabis cultivation. I think what they're trying to get at is, did you install a number of powerful lights or something like that, or there's some type of other alteration that was going on. for cannabis. So that's how you know we're in 2022, is that you have that type of question on this document. Let me go back to my slideshow on this, because I want to highlight something here regarding tips and what I call tips and tricks. So those of you who have taken my other courses know that I try to give tips and tricks for buyers and for seller agents on what to do when you get a red flag or when you get a disclosure issue. In this particular, I'm talking about the SBQ disclosure issue. So what does the buyer agent do? First of all, if you get a sheet that has a number of of disclosure issues on the SBQ, I mean, certainly don't panic. You really got to tell your buyer that no house is perfect. Even a brand new house should have some disclosure issues, because there's nothing that's perfect out there. But rely upon and defer to experts. This is extremely important that you do this. That if there's an issue, like it says there's a roof issue, like they identify a roof issue, they identify a plumbing issue, recommend and defer to an expert. Unless you're an expert plumber, which most of you aren't, I wouldn't be opining about, I'm not an expert plumber, I wouldn't be opining about whether the work that was completed was done correctly. So I would definitely rely, and the way you do that is you say, we talked, the SBQ disclosed a recent repair to the plumbing. Buyer, I advise you that if that's important to you to verify whether it was done correctly, they haven't provided anything about it other than this statement. You hire a licensed plumber to investigate this work, or a general contractor or something like that. If you don't want to do that, that's fine. But that's my recommendation. You could wordsmith that a bit, but that's essentially, that's the type of thing where if you have that in the file, you don't get a claim against you, because they don't get to argue, oh yeah, Fred, my agent said, that's no problem. Look, the faucet looks great. I'm sure the plumbing is fine. Don't worry about that. Release your contingency, right? That's what they'll say. You said, even if you didn't. They always say that. But if you have it in writing, it's hard for them to say that. So there's my next thing. Recommend in writing that the buyer investigate. And avoid guessing, theorizing, or speculating. Of course, don't guess as to what the outcome may be, or how the repair was done, or what is the fill stable in the backyard, or how long the roof will last. None of that stuff should be something that you guess on or theorize or speculate. And then always do this: document the source of the information. When you get information from someone, document the source so that so that you can verify, so that they can verify. Well, let me back up. I don't want to say verify. So that they know that this information didn't come from you. One of the scariest things that happens, I see, is the buyer says, well, did they get permits? And then the buyer or the buyer's agent goes and it gets, they say that there's permits, and then the buyer comes back or the buyer's agent comes back and says, yeah, there are permits. The permits are great. Buyer's agent never saw the permits and never said, I got this from the seller. The seller says there's permits, but I'm not verifying. Yet I don't know. Instead, the buyer's agent said, oh yeah, there's permits. Well, guess what? You just guaranteed there's permits, right? So document the source of information. Attribute who it came from. And what should the seller do? Well, the seller agent, it sounds like a broken record, but document the issue in writing and copy all parties, right? That if you have an issue that's in they've provided less than a thorough explanation. They say perhaps they don't have the documents, right? Perhaps they really don't have it. Document in writing that you ask them to provide it. Consult with your broker. This is also extremely important when you're disclosing items The reason why you have your broker to some extent is to help you through challenging issues in a transaction. And one of those is when you have disclosure issues. Log your conversations, right? When, oftentimes sellers won't necessarily put in their SBQ all the issues but they'll tell you these things, right? They'll tell you verbally, oh yeah, we did a remodel last year. And then you look at the SBQ and it doesn't, it's not in there, right? So logging your conversations about the issue and, and advising them appropriately as to what their obligations are to disclose. And, don't assume, and this is also the fact that don't assume the seller's expertise. Oftentimes they will try to hide the issue because they think it reduces the value of their property. And of course, disclose the issue in writing. I've had many cases where people, the seller's agent calls me up and says, we disclosed everything about this issue to them. And I say, well, how did you do it? And they said, well, I told that agent. I had a conversation with that agent. And I said, well, was it in writing? There's a text message about it. And I look at the text message, and the text message is, it looks like something my teenager wrote, and it said, with acronyms, and it's all of half a sentence. And I was like, is that the disclosure you're talking about? And they say, I talked to them about it. Well, I'll tell you this, if it isn't in writing, it didn't happen. So please disclose all issues in writing. Okay, so that was our SBQ. And I know we have several items left. We have several documents left. So, but these ones will take less time because there's less at issue in them. But I wanted to, before we go on, that common disclosure issue, I'm just going to show you the slide on it, which is the, well, before we get into that, the common disclosure scenario, that flip house, I encourage you again to get the correct documents, get the original documents from when they first purchased the property. And if they won't provide them, or they say they don't exist, certainly they're lying, right? Because if you bought it 6 months ago, everyone has everything digital now. That means that they're probably lying. And that's something I'd want to inform my client of and say, this professional flipper says they don't have the documents from 6 months ago, right? That doesn't sound right to me. I would advise, you make the decision, buyer, whether you still want to go forward with this transaction. So that's the type of thing that I would ask for in a situation like that. So next item is, this is the request for repair. So what we're going to talk about here in the request for repair is, how does this work? What are the new FHA and VA terms? And then really what else has changed? And we'll try to get into a disclosure scenario. But let me go to the document itself. So the request for repair is a form that is often used, and my personal preference on this, and you didn't ask for it, but you're getting it because you're listening to me. My personal preference is not to do work for a buyer. That if a buyer wants work to be done, that you just give them a credit instead. Because I've had a number of issues where either the work just wasn't done, or it wasn't done the correct way, or at least to the satisfaction, and I'm using correct in air quotes here, it wasn't done to the satisfaction of the buyer. And sometimes that's revealed when they inspect it. Sometimes that's revealed months later or weeks later when they realize that that roof repair that they thought they were getting was done by the homeowner himself. And let's just say it wasn't, wasn't a good, it wasn't done well. And so what I like to see on most of these, or when I generally counsel people, is just get a credit. Just get either a credit that is given to the buyer, or if you have a lender issue, a reduction in price. That is often cleaner than doing work that you don't know how long it's going to take. You don't know who they're going to use, and you can also specify who they use, but it's often a recipe for delay and a recipe for, was it done correctly? Did we like it? I mean, it just, there's more problems than solutions, I think, when you do that. However, the way the request for repair works, as many of you know, but I'll go through it here, is that the buyer has essentially some options. The buyer wants a repair. They see that there's a problem, and so they want they make this request here. And so the request is essentially, are they going to verify are they going to do this work? And what I like to see on this is to attach a report or attach an estimate. So what I see problems with, someone says fix the roof. Much better is to say, make these specified repairs pursuant to this estimate and this report from the roofing company. I think that's way better and much better, and even specifying who the contractor is, I think is much cleaner and can lead to less disputes. Of course, you're saying, well, gosh, why would the seller in a seller's market agree to that? Different story. But, the market will turn again. And I like to see a specificity in a buyer's repair request if you're going to check 1A. If you're not going to do that, you're not going to check 1A. 1B this is really the termite. This is the termite work, or the section 1, section 2. That's really going to be based off of almost, they even have it in here, but it's always based off a report. The third one is the seller credit. And this is, I said, sometimes my preference, but this is the type of issue that can get you into trouble. And there's a nice handy note here regarding that this credit could be a problem. It needs to be disclosed to a lender. They may not allow it. Oftentimes you need to check on that, whether that's going to be a problem for you. But if it's not, then it's just this 1D, which is request that you modify the purchase price. That's probably the best one. That's the one I like to see. So what's new on this form? You guys, a lot of you are like, I know all that, Fred, already. What's new on this form? Well, it's this FHA VA section, because as many of you who do this type of work, the lender often requires specific repairs to be made or specific items to be fixed. And so this new section here highlights that, and it creates a new section here for that area. Now, I'm not an expert on FHA and VA loans. I don't pretend to be, but what this issue is trying to solve for is it's trying to solve for that problem of the seller doesn't really know that this will kill the deal, essentially, because they have someone who has a FHA or a VA loan that if they don't do these repairs, if they're not done, then it could kill the loan. So they're trying to highlight that because that's a particular problem that people are seeing. So what else is important here? Certainly this expiration language, and this is new as well here. I think they're clarifying when this request for repairs expires, and you'll notice that they specify specifically that it's 5 p.m. by the third day, unless it's signed, it's and delivered. Then we have an issue, or that it expires, or if it's withdrawn. So I would walk you through with your buyer before you do this as to what the possible scenarios are. Okay, they agree, they partially agree, they refuse, or gosh, what if they don't respond at all? And so I would walk them through that, because sometimes people don't realize that that might happen. And so then we get to the page 2 here. And this is a new section up here, the effect of the buyer request. On the, they want to make it clear that if there's any previous document that it can be incorporated. But here's essentially your options as a seller when you're responding to this. You can either respond on this form, and I would do that if it's a fairly minor issue. Like, let's say they said they had, repair the doorknobs in the kitchen. I don't think you need a separate form for that. I think you could agree to that here, or you could do a partial, say, no, I'm not, I'm only going to agree to repair one of those doorknobs. That this is, I would use this form or this section for a fairly minor. But if it's, one of those 30, or 17 point repair requests, and you're planning on doing 3 of the 17, and maybe giving a credit for another one, just check this box to respond with the attached form. Do the my favorite, the RRRR form, because I think that's really it allows for a more comprehensive response. But you can do it all in this form if you want to. But before we get to that form, because there's this note. Remember, I said the FHA VA section. Well, here is your note. I don't know why they put it here at the end, but it's important, I think, to talk to them about this. That if you don't reach an agreement on this, you may no longer be eligible. So what people sometimes are doing is they're releasing their contingency, they're getting denied on this repair, and then they're losing eligibility for their loan. And so that's a real problem, and so that's a real thing you need to talk to them about. And so there's this handy note here. So I would highlight that if you are in the FHA VA world. Make sure to highlight this. You're probably already on top of it, but if you're not, know that this is some new language in here to help, I think, to help guide you a bit. So the other form, and I won't spend a ton of time on this, but this is the RRR form, R. And this is a similar form. There's just a bit cleaner. So if I'm looking at a response, I tend to like to use this form unless it's minor. But I mean, one of the keys to these forms, and it sounds silly, but one of the keys to these forms is making sure they're all filled out correctly. What I tend to see on some cases is people miss things in these forms, particularly if they're handwriting these things, and so they're just incomplete forms. Don't make incomplete forms. I know you might say, well, it's the broker's job to make sure. That's the TC's job to make sure everything is checked. Well, ultimately, it's your job too. It's your job to make sure everything is correct on these. So this is something I would go through with them when you're answering this form. You'll notice that obviously I like this form because it's a little bit longer and it has a little bit more information, but you have that same language here. If you'll notice it, so you say, what's changed on this form? Well, here you go. Note to seller. This is warning them that if they don't do these requests for repair, they might not get the loan, and you might have to start over with a new transaction. So I think it's encouraging here the seller to not be completely stingy on this. That the seller, some of these repairs may need to be made if they're going to get eligibility for a loan. And that's also, there's identical language here on the buy side here. There's another nice warning about this, that, as to the VHA, or I'm sorry, the VA and FHA. One item before we move on from this is the expiration timing. So this expiration timing up here is mirrors on the RR form. This is the type of thing I would calendar. Once you're, I know you probably calendar everything in a transaction, or you have someone who does that, but I often see this being a point of contention, is that people don't calendar this. They send this form off. They don't calendar the response, and they're getting responses that are after the expiration, or they get into, what I'd call somewhat minor disputes, but they get into disputes over whether it's been accepted or not and what the timing of it is. And meanwhile, contingencies are or at least the time of the transaction, escrow is still carrying on, and they're not getting a response. So I'd be on top of the request for repair with a calendar entry so that you're not missing any deadlines there. Okay, so we have 3 forms left, and I'll go through these forms. Will actually take a little bit less time than the other forms, and then I'll open it up. I'll check out the questions that we have and open it up for some questions. But before we get into that, I'm going to do the contingency removal form. And let me pull that up for you. This is the form I know you all love because everyone's waiving their contingency. It's the new thing to do, right? Everyone waives their contingencies with their offer because they want to have the prettiest offer. And besides the fact that that's extremely risky, I understand the reason for it. I let you let the client do what they want to do. If they want to remove all contingencies because they really want this house, you can do that. I just make sure that it says in bold print that that's against the advice of the agent and the broker, but you can let them do it. But how does this work? Okay, so let's start with the beginning of this form. The contingency removal form is really structured to get you past that, to have your money go hard, to get past that, that opening look, the free look at the property, and get you to the point where, the parties are moving towards closing, right? And there's a lot of contingencies. And what was extremely helpful, and I thought the real benefit of the RPA, the new RPA, was that they put all the contingencies together. They're in that, that grid that we have, they're all now in that one grid. And so you can kind of highlight that to your client when you're making the offer. And even when you're reviewing the offer, you can highlight, okay, these are the deadlines that are going to be important for us, right? But to release those contingencies, you're to do that in writing and to do it with this particular form. And so what you might end up doing here is you might have multiple copies of this form because you might be releasing contingencies at different times for different items. And that's the way this form works. So you can either remove all buyer contingencies at the end, which is section 4 here, hereby removes all, and that kind of wipes the slate clean, right? That's the really easy one. That's if you're the seller, you love that. But what if you don't do that? What if there's an issue in the transaction regarding something? Like what if it's the loan, the appraisal? So the way this works is each one of these, each letter here and 2 is independent, right? So if you're removing something specific, you're going to remove that. You're going to remove that item by each checkbox, and the information here. So like we're looking at 2A. It says loan. So paragraph 3L1 and 8A. What are those? Those are the paragraphs in the new RPA that reference this loan contingency. 3L1 is the grid section, and 8A is the contingency itself. Remember the way that grid works is you look at, here's the negotiable term is in 3, and then the detail about that contingency or the detail about that term is then later on in a different paragraph in the RPA. So that's the way this works, so that you can guide your client and say, well, okay, are we going to release that? Where is it? Okay, there it is. The one that's pretty interesting here is this section here is the investigation of the property. And you'll notice that they have really split this into different ways you can do the investigation, because the investigation of the property there's multiple ways you can investigate it. So you could do an entire paragraph 12, or you can do just the buyer walkthrough essentially, which is 12B1. Now, or they have here 12B2 and 3. Those are the statutory inspections. So that's slightly different. So you would check one or the other. So you're either checking one, or you're doing two, or you're doing or three or four. And this is kind of the catch-all of, you're releasing everything except for the roof, or except for this one issue, the garage, or something like that. If there's some type of exception, that's where you would put it in here. It's a really nuanced section here, but that's I think important to so you don't release all the contingency if you don't intend to do it. Make sure you put the exception there. Other items that are new here, this review of documents. Here's one that's new, is 9B6. You're thinking, well, what's 9B6? That is the leased or liened items that they're supposed to provide those documents. Those are specifically called out now, and you're to review those, and you may not release that contingency, right? Because you might still be working with the solar company to transfer that lease. And so that's something that might take longer than the 17 days that are or whatever your contingency period may be. That might take longer. And so that's something you don't want to release, because what if it doesn't happen, right? It's not something you want to release right off the bat. So that's another item that is new. Once you provide this form, the seller is to countersign it. But you'll notice on here, I just want to highlight one thing. Seller has some contingencies, right? There's some seller contingencies that could be out there, and it really has to do with finding that replacement property if that was a contingency of the original transaction. So the seller can actually remove contingencies on this form too. But this generally, what you're using this form, all of you probably are using this form for the buyer release of contingency. So, last two forms in our that we're going to look at. And these forms are fairly similar, but I will highlight a couple of differences. And I'm going to start with the notice to the buyer to perform. And the reason why I start with this is most of the time the buyer is the one who's not performing for some reason. And I'm not coming down on buyers. It's just that buyers have a lot more to do sometimes than the seller. They have a lot of due diligence. They don't know much about the property. They're doing this due diligence. They're doing it in a very compacted time frame because the sellers have the upper hand right now. So they're trying to do everything within 10 days, 17 days. They're working really quickly. And often they're missing deadlines. And so my first take on this document, as you see it here in front of you, is that I think it's much better. I think the clarity of this and the specificity is helpful. One of the problems we've had previously with notice to perform is that it didn't really incorporate all the specific issues. And so what agents were having to do is they'd have to write in what the issue was. They were having to essentially add text to the document, and then they'd get into an issue of, did that give enough specificity? Was that really the issue? I think that this is helpful and addresses more of the items, but I'm sure there'll be flaws in this document as we start to use it and I start to see claims coming off of it. I've not yet seen this one come up yet in the last couple of months, but I'm sure it will. I do like the way this is organized now, that it's organized with the contingencies, because the contingencies I think are more important than the contractual actions. But ultimately they're all pretty important. I don't like the numbering here of the A through CC, but But regardless, the contingencies I think are most important because those are the ones that people don't waive. They just miss the deadline for whatever reason. And that's often what you are enforcing. And that's why it's so important to calendar the contingency periods as the seller's agent, because if you're going to enforce this is you want to be on the spot with this, because we'll talk about the timing in just a second. But what is new on here? If you're looking at here, and what are these new contingencies? Well, a couple I want to highlight for you that are really interesting to me. Buyer investigation, including insurability. I know it's been a real point of contention, particularly in the fire-prone areas, that people find out that they can't get insurance on the property, or that insurance is available, but it's wildly expensive, and they weren't expecting that, and so this is a kind of a highlight to that of, okay, make sure that that's part of your analysis. Another one here is the buyer review of leased or liened items. Remember, we talked about that. Here's that review. Was that released? The closing on escrow of buyer's property and the entering of contract for sale for buyer's property. The COP form. These are it's the same document. We could just say, the release for contingency in the COP. I like the specificity of saying, well, there's really two different things there. And so I like that specificity in this document. Regarding the contractual actions, if you take a look at this section here, we have a whole number of contractual actions which they need to do. So if they're not doing something that they're supposed to do, this is where you come in and enforce it. And you're saying, well, come on, everyone returns the lead disclosure. They just sign that document and they get it done. Where I see this as a particular problem, by the way, is in the dual agency transaction. And I'm not ripping on dual agency, but what I see is it's sometimes more of a casual use of documents that they say, because they got to sign it themselves, they got to deliver it to both sides, or someone in their office has to deliver it to both sides, and they don't end up getting it done, or sometimes they don't do it before the close of escrow, or they don't do it in a timely manner before contingencies are released. And when you do that, you leave yourself open to criticism later. And I'm not saying you lose your case or that, there is a lead issue, for instance, but you leave yourself open to criticism, and in particularly in the dual agency transactions, because the courts don't like them, arbitrators don't like them, a DRE doesn't like them. No one seems to like an agent who misses deadlines in a dual agency transaction. There's just more scrutiny on them. Particularly if an issue comes up because one of either the buyer or seller says, you didn't have my best interest in heart. And it's an easy argument for them to make, because if a dispute arises, and you don't have good paperwork, like you're not delivering things on time, and you're not sending a buyer notice to perform, then you open yourself up to criticism. So that's my rant on that is, if you're in a dual agency transaction, make sure you're very good on the forms. You're on top of it. It's not the time to drop the ball. And in fact, the absolute opposite. That's the case where I would make sure I'm 100% on top of everything, because you know that you could be scrutinized more aggressively after the fact. Okay. So one last item on here is this section I want to highlight at the bottom. Well, right before I do that, this section, or this new sentence here, applicable paragraph numbers for each contingency or contractual action in other CA contracts may be different. You're thinking, well, what does that mean? Well, what they're really talking about here is that the intent of these paragraph numbers up here are to be in the RPA. And so if you're looking in, if you're looking somewhere else for these paragraphs, they're just trying to let you know that don't look, the reference to is to the RPA, not to some other document. But this is the last thing I want to highlight here on this form, which is the timing of this. And this is, and you'll notice here, this section here, and this is what I want to highlight. If you remember from the RPA class, or you've just been looking at that document, they hard coded in the notice to perform. In the past, that you could really edit it, and some people were doing, like, they would put 0 days, or they would put in, I'd see all sorts of different things. 1 day, sometimes even sometimes they would put it longer, but now it's hard coded in. And so what they're specifying here, and they're making it clear that this notice to perform can't be less than 2 days. The default is 2 days, but it can't be less than 2 days. And what I think they're trying to do here is the weekend problem, right? Or the holiday problem, that if you require someone to do something like that on a holiday or on a weekend, you're making it that much more difficult for someone to comply. And you're also, and what does that mean in the long run? That means more disputes, right? You tell them, you have to release this contingency, and then they fail to do it, and then you say, well, we're canceling the contract, and they say, no, you're not, right? You didn't give me this, or you didn't give me that. And that's, what does that lead to? That leads to disputes. That leads to people calling me, which, call me, but I don't want to shy you away from doing that. But it would be much nicer if they could get through a transaction without a dispute over, what day of the week someone had to perform something, and get to the actual substance of the issue. So one thing I want to highlight here, as I just move on, is, days is defined. So look in the RPA, it defines what a day is. And it also has this handy section of counting days, how to calculate days, how do you count days. So I'm not going to belabor the point, but read that. I'd always read that every once in a while and I read it every once in a while to make sure that I'm right on the days. When someone asks me, oh, how many days for this or how many days for that, it's always a good idea to read that and walk a client through it. So if days become an issue, because it's there, it's a nice definition, and it's important for something like this. And that's in paragraph 25, is all the definitions of the of things like days and how to count days. Okay, last form, and then I promise I'll let you all go. For those of you who are still here, and we have a good 25 people. The last form isn't too much different than this, but it's the seller to perform document. So it's not just the buyer who needs to perform, it's also that seller. And I think I told you earlier, and I'll reiterate it, I've had more notices for a seller to perform in the past 2 years than in the 10 plus years before that combined. There's just been a lot of sellers, for whatever reason, have not wanted to, I blame it somewhat on the nervousness of coronavirus, of moving, but I think it's mostly that the market was appreciating so quickly that they got into a contract and realized, oh my gosh, the neighbor sold for 50 grand more. How do I get out of this contract and get a new deal? Or it's been that they really want to sell, the price is fine, but gosh, they can't find anywhere else to live. Nothing else was available. Inventory was so low that they couldn't find that replacement house, or they couldn't even find a replacement apartment that they wanted. And so what they were doing was they were either slow walking a transaction or not cooperating with the buyer in some kind of an attempt to either what I call shake them out of the deal, or to just try to cancel the deal that they couldn't cancel, at least not legally. So how do you remedy that? If you're on the buy side, well, you send them a notice of seller to perform. And this is that document. And guess what? Just like a lot of other forms, there's new clauses here. And this is different than the notice to close. So just make sure that if you're at the end of the transaction, you're using that form. This is more for those contingencies or those contractual issues that come up during the middle of the transaction. So some of the new items, that those leased and lien systems, everyone's very excited about that. That's the solar traditionally, but it could be other things. There could be other things that they lease or lien on the property. Sometimes electronics, some of these smart home systems, I think they're leasing those. So that's a new one. This section on the statutory or supplemental disclosures, if they're failing to provide that SPQ that we know and love, here is fully completed. So notice I like that. Make sure it's fully completed, not just halfway completed. And so that's something that needs to be provided. So sometimes they'll just be late on that, right? And if they're late on that, that's something that you need a notice to perform on. And then you obviously see things like I'll highlight this one, the fire hardening. That everyone knows and loves that one. No disputes about that one, right? I laugh because I've had so many calls on the fire hardening over the last couple of years because nobody understands it. Everyone was confused, particularly when it first came out. And what am I supposed to do? The seller doesn't live here. What are they supposed to do? There's lots of questions about the how do I call the fire department? They don't answer the phone. There's lots of the questions about that. But this is, I'm not going to get into that. That's a separate discussion. But this is where if they don't provide it, this is where you're supposed to ask for it, right? If they're late on it, there might be a reason because they don't know what to do. But this is where you kind of force their hand as to releasing that. The other ones on here, condominium, the earthquake, those are obviously important. This disclosure, authorized to act in a representative or capacity. Here's my shameless plug for an elder abuse course. If you want to take my elder abuse course, it really a lot of it has to do with who has authority to sign for things, right? Who is the trustee? Who is the seller? Oftentimes it's confusing. I talk about that extensively in that class because that's a real elder abuse issue, financial elder abuse. I don't mean, physical. I mean financial elder abuse where someone takes an elder's property, but it could happen even if they're not an elder. It's just that's where we often see it. The delivery, the one last one here is the delivery of an inspection or report. If they said they're going to provide you that geotech report, and they don't provide it to you, here's where that might be enforced. You also have this really handy, and by the way, here's the other contingencies of those seller contingencies, right? Those two from the finding replacement property. Here's another item that is new. This paragraph, remember that we had that reminder earlier about that the paragraph numbers refer to the RPA, not to some other form, but these things like the three N's up here that are up in the document, those are all part of the RPA sections of what should be delivered. So last item, and then we are actually done, is the 2 days. So again, just like mirroring the other document, there is this no less than 2 days. So they're reminding you that this is there's a 2 day time frame for this notice to perform. And so do not make it less, and do not try to enforce that this is hard coded into the RPA. So that's a final notice on there for you. And that is my presentation for today. I hope this was helpful. I'm going to give you my number here, and then I'll check the chat. I know there's a few questions in there, but I just want to make sure that everyone has my contact information before I do that. That's just for 1 second. So here's my contact information. Like I said, my firm is here to help in your transaction. I strongly encourage you that if you have a problem in your transaction, certainly go to your broker. Your broker or you can come to us. We're there to help. We often do a conflict check. We're required to do a conflict check. So if you do call, please know that we may have to do that may delay things slightly, but I'm more than happy to answer questions for you and be available as much as I possibly can, because I want to help the community and certainly help my North County realtors to make sure that you're in compliance and you're not getting claims. The goal here is claim avoidance, not getting in lawsuits. But let me take a look at the chat here. There was one question from Chelsea. Where can I access this recording? That's a good question for Shirley. Shirley records these and replay them. Hopefully I said the right thing. In real time, sometimes it's always a bit difficult to make sure you're getting, you're being as clear as possible, but I do my best here. And like I said, if you have specific follow-ups for your specific transaction, I strongly encourage you to talk to me, another attorney in my office, or your own attorney of your choice, because while this is, while we talk a lot about certain things here and general advice, every transaction is different. I know that's kind of a cliche, but everyone is. And what we might talk about here may not work for your specific fact pattern. So I strongly encourage you to check out NSD Realtors, realtorstv.com. They have their own site. Someone asked, did you say seller must countersign the CR? I took the lower section seller signature to apply to if seller is removing a seller contingency. So what we're looking at on yes, that is correct. If I said that, I apologize. That is a section that it's only signed if they're removing a seller contingency. It's not for, I'm sorry if I misspoke there, but this is for the buyer. This is really a buyer document unless the seller is releasing that, those two contingencies, or I guess there could be another contingency the seller is releasing but that would have to be, a contingency that's not otherwise in the contract, a contingency that was added, something ad-libbed. But I apologize if I said that incorrectly. You are correct. This is really for the buyer to release that contingency. And it looks like that is, we have another couple questions. I love the way Zoom they have a chat function and they have a Q&A section. So Guadalupe asked, will these forms populate when checked? That was the stated goal. So the stated goal that I heard from CAR, even before they released a number of these forms, I not only attended their initial training on some of these forms, but I was there at the CAR convention when they talked about, okay, this is what we're thinking. Attorneys, what is your input on this? One of the expressed goals that I heard was that if you go in zip forms and you check these boxes, it'll automatically populate. And that's the real goal of this RPA, is that it has so many internal references, and we're gonna make it so it's easier for people to not miss forms. And then I heard that some of the forms weren't populating correctly when they first released it. I have not checked on all these forms. I'm not their Q&A or their QA person, but the intent was to do that. And I think that's a laudable goal, because if, it's very easy to miss a form. I mean, I have a book here. I have the form book. It is this thick. of all the forms, and they add new ones every year, and it's very easy to miss a form, particularly an important one. And so auto-populating really saves you time, and it saves you from just frankly missing something. One last question, it looks like here, and this is from Patricia Blackwell. She says, SPQ, how would this be completed when a property is an inheritance property? So what I think you're asking is, okay, we have a property that isn't a, the seller has never lived there. That's always their, you know, that's always what they try to fall back on, is that, you know, they've never lived there. They have no knowledge of the property. I often find that to be, you know, somewhat hard to believe, that they have no information about the property. But if it's really true, that's part of what they're having to disclose. I mean, I think that's a disclosure in itself, that the seller doesn't have information. Now, if it turns out to be false, you know, I think that's a real problem for the seller. I've had a number of cases where they say, you know, that was my aunt's property. I don't know anything about it, right? And then you find, and then they don't disclose anything, or they disclose very, very little. And then you find out later on that they've been there, you know, dozens of times. And they, you know, they were in possession of documents. They were in possession of their late aunt's documents that talked about things. And they said, well, I have no knowledge of it. Yeah, you do. You had it in your possession, right? You can be criticized for that, potentially. So it's something that I would really, before I went down the path of we know nothing, you know, buyer beware. That's really not the law in California. So it's, I would be very careful before I did something like that. And we could talk about the specifics of that inheritance if you have questions on that after the fact. I'm more than happy to talk to you, Patricia, to go over something like that. But it looks like that is that we're exactly at 11:30 now. So that is what we were slated for today. And I thank all of you who stuck around and heard this today. And I hope it was helpful. I hope you got something out of it. And I'm more than happy again to talk to you further on something like this. You have my email, you have my phone number, and I thank you again. I thank North San Diego County Realtors for having me, and I hope you all have a great day and happy transactions, right? Good transactions. So thank you, everyone, and I'll see you next time.
Thanks, Brett.